Okay.
This meeting is being recorded.
All right. Good morning, everyone. This hearing before the Connecticut Office of Health Strategy is identified by docket number 22-32516-CON. Pursuant to section 19A-653 of the Connecticut General Statutes, the petitioner in this matter, the Connecticut Office of Health Strategy, issued a notice of civil penalty in the amount of $118,000 to the respondent, Prospect Rockville Hospital, Inc., DBA Rockville General Hospital, relating to its alleged failure to seek certificate of need approval under Connecticut General Statutes, section 19A-638, parentheses A, for the termination of surgical and procedural services. Thereafter, the respondent requested a hearing to contest the imposition of the civil penalty, and OHS issued a notice of hearing. Today is May 18th, 2022. My name is Daniel Chuka. Executive Director Vicky Veltri designated me to be the hearing officer, and I will be issuing the final order in this matter. Also present on behalf of the agency today is Jessica Rival. She's a healthcare analyst who may be assisting me today as needed. There are also several other members of OHS who are also present, and they'll introduce themselves later on in this video. Public Act number 22-3 authorizes an agency to hold a public hearing by means of electronic equipment in accordance with the Public Act. Any person who participates orally in an electronic meeting shall make a good faith effort to state his or her name and title at the outset of each occasion that the person participates orally. I note that there are a number of people present for this hearing today. I ask that all members of the public please mute the device that they are using to access the hearing and silence any additional devices that are around them. This public hearing is held pursuant to Connecticut General Statutes, section 19A-653, and will be conducted under the provisions of Chapter 54 of the General Statutes. The Certificate of Need process is a regulatory process, and as such, the highest level of respect will be accorded to the petitioner, the respondent, and other OHS staff. Our priority is the integrity and transparency of this process. Accordingly, decorum must be maintained by all present during these proceedings. This hearing will be transcribed and recorded, and the video will also be made available on the OHS website and its YouTube account. All documents related to this hearing that have been or will be submitted to OHS are available for review through our electronic CON portal, which is accessible on OHS's website. Although this hearing is open to the public, as mentioned in the agenda for today's hearing, only the petitioner, the respondent, OHS, and their respective representatives will be making comments, presenting witnesses, and presenting evidence. Accordingly, the chat feature for this Zoom call has been disabled. As this hearing is being held virtually, we ask that anyone speaking, to the extent possible, also enable the use of their video cameras when speaking during their proceedings. In addition, anyone who is not speaking shall mute their electronic devices. Lastly, as Zoom hopefully notified you in the course of entering this meeting, I wish to point out that by appearing on camera in this virtual hearing, you are consenting to being filmed. If you wish to revoke your consent, please do so at this time. Moving on, the CON portal contains the table of record as of yesterday afternoon. As of this morning, exhibits were identified from A to R. Does either party have any objection to these being entered into the record as full exhibits?
Michelle Holby for respondent, Rockville Hospital. I have no objection to the table of contents, the table of records.
Thank you, Ms. Volpe. Ms. Manzone, do you have any objection?
No objection.
Thank you. In accordance with Connecticut General
We can't
Statutes.
see your, we can't.
I'm sorry.
Might just be me, but I don't think we can see your image.
Is anyone else
others
having
see?
difficulty seeing me?
I can see Dan.
I
Okay.
see you.
I can see
Okay.
you as well.
Must just be me. Sorry.
You might be on a different screen, Lara.
Yeah, maybe change the
Use the
view.
arrows of the left and right arrows.
Good idea. Thanks. It's all right. I know what he looks like. I will try another screen. Okay, there we go.
Okay.
Thank you.
In accordance with Connecticut General Statute, Section 4-178, the parties are hereby noticed that I may take administrative notice of the following documents: the statewide healthcare facilities and services plan, the facilities and services inventory, the OHS acute care hospital discharge database, the hospital reporting system, HRS, financial and utilization data, and the all payer claims database claims data. I am taking administrative notice of the following OHS dockets, which were referred to in various places throughout the participants' submissions to OHS. They are docket number 20-32361-CONW. That is the docket relating to Rockville General Hospital's request for a waiver at the start of COVID. Docket number 20-32405-CON. That is the termination or the application for termination of Rockville's license and consolidation with Manchester Memorial Hospital. And the third one is docket number 21-32508-DTR. That is the determination request in which Rockville sought an extension of its COVID waiver, among other things. I may also take administrative notice of other existing OHS dockets, whether currently pending or not, and prior OHS final decisions, proposed final decisions, and agreed settlements, which may be relevant to this matter. At this time, I would like to ask Ms. Rival, my assistant, if there are any other exhibits that she is aware of that needed to be added to the record this morning.
No, none that I'm aware of.
Okay, thank you. I also wanted to point out that in addition to this piece of paper in front of me and the laptop that I'm working from, I also have another laptop here as well as another monitor. So if you see me looking over in that direction, it's not that I am not paying attention to you. I definitely am. It's just that I am looking in the other direction at something for some particular reason. So I'm going to start with counsel for the petitioner. That's OHS. Can you please identify yourself for the record? Ms. Manzione, I believe you are muted.
Good morning. I
Good morning.
have unmuted myself successfully. It's a good start for the day. Okay, I am Lara Manzione. I represent the petitioner, the Office of Health Strategy.
And would you mind spelling your name, if you don't mind?
Sure, I will spell both names. Lara is Lara. Manzione is MANZ like zebra, IONE.
Thank you. And I believe I cut you off. I'm sorry. Were you planning to say something else?
No, I was going to say, if it pleases the court, I would start with my opening statement.
We will get to that. There are a few other things that I wanted to iron out first.
Okay.
I did want to have counsel for the respondent identify herself as well.
Sure. Thank you, Hearing Officer Shuka. My name is Michelle with one L, Volpe, V as in Victor, O, L, P as in Peter, E. I'm legal counsel for Rockville General Hospital.
Thank you. Do either of you have any additional exhibits that you would like to enter into the record at this time?
No, I do not.
No.
Okay, thank you. And are there any other documents or dockets that you would like me to take administrative notice at this time? Certainly, if they come up in the course of testimony or in other places in the hearing, you could ask that I take notice of those at that time as well.
Yeah, for purposes of the record, as part of our brief and pre-file testimony, we have reference to numerous executive orders of the governor, as well as various OHS guidance and rulings and forms. So it's our understanding that since those are exhibits and part of our filings, that those are obviously in the record. And to the extent we reference them in our statements, we direct you to the relevant numbers. But our understanding is those are all part of the record as well.
That's correct. That's why I didn't mention those earlier. But in the event there is something else that has been left out, feel free to bring that up, and I'm happy to take notice of it as well.
Very good, thank you.
Ms. Manzione, anything?
No,
Thank you.
I think we are
Um,
officially administratively noticed. Everything was in the record.
So we haven't done one of these hearings in quite some time. This also is my first hearing as hearing officer for OHS. So we are bound to encounter some bumps here and there, but we will do our best to get through them. So we're going to proceed in the order established in the revised agenda filed yesterday for today's hearing. Are there any other housekeeping matters or procedural issues that either of you would like to bring up at this time?
None from respondent, thank you.
Ms. Manzione, anything?
I think at the end of closing arguments, maybe we can talk about if there's any need for further briefs.
Okay. I am happy to discuss those afterwards. So with that in mind, I guess we will proceed to petitioner's opening statement, and I give you the floor, Ms. Manzione.
Thank you. Okay, good morning. Good morning, Hearing Officer Chuka, Attorney Volpe, representatives of Rockville General Hospital and the Office of Health Strategy, members of the healthcare community and other interested parties. My name is Laura Manzione and I represent the Office of Health Strategy. Today's case is all about following the rules. It's about who makes the rules and who has to follow the rules. It's also about how we interpret the words that are used in rules. In today's case, the main rules we are interested in are statutes, which are rules made by the Connecticut General Assembly. One rule is Connecticut General Statute Section 19A-638A5. This rule requires that a certificate of need, or a CON, must be issued in order to terminate inpatient or outpatient services offered by a hospital. The other related rule is Connecticut General Statute Section 19A-653. It states that if a healthcare facility or institution that is required to file a CON under Section 19A-638 willfully fails to seek CON approval for any of the activities in 19A-638, they shall be subject to a civil penalty of up to $1,000 a day for each day such healthcare facility or institution conducts any of the described activities without certificate of need approval as required by section 19A-638. The evidence presented today will show that Rockville General Hospital broke these rules, and Rockville General Hospital knew that they broke the rules and broke them willfully, and that they don't think the penalty for breaking the rules should apply to them. Healthcare is a very regulated industry. That's why hospitals and the agencies that regulate them need so many lawyers like me and like Ms. Volpe, my opposing counsel. It's our job to interpret the many rules and regulations that apply, whether from the federal government about things like Medicare and Medicaid, or from the state legislature, like the certificate of need laws. During the time period at issue, the evidence will show that the governor issued a series of rules of his own. His rules are called executive orders, and they were extraordinary measures taken to address the nascent pandemic. One of his early ones, Executive Order 7B, was issued on March 14th, 2020, and among other things, gave the executive director of the Office of Health Strategy the authority to waive provisions of statutory and regulatory requirements to ensure adequate healthcare resources and facilities were available to respond to the COVID-19 pandemic. The executive director followed that order and created CON waiver requests for hospitals and institutions so they could rework their facilities quickly to help better align resources to treat the growing number of people with infections. The evidence will show that on March 24th, 2021, Rockville General Hospital sought a CON waiver to close its operating rooms in the gastroenterology surgery unit, the pre-op and post-anesthesia care unit, PACU, areas, and to repurpose these spaces to treat COVID patients. The following day, March 25th, 2021, OHS approved of the CON waiver for Rockville General Hospital to do so. The CON waiver stated that once the pandemic was over, they would have to apply for a full CON if they wished to permanently terminate any services. The evidence will show that approximately 1 year later, a new rule, Executive Order 12B, was issued by the governor that rescinded the wide authority granted to the OHS executive director, effective as of June 30th, 2021. The evidence will also show that OHS issued a guidance document explaining the rules a few months later on October 22nd, 2021, clarifying that all hospitals that had received a CON waiver should be back to pre-waiver conditions. Continued suspension would constitute a violation of CON statutes and regulations. The evidence will further show that even though Rockville General Hospital received this explicit notice of the rules directly from the OHS that they should be back to pre-waiver conditions, Rockville General Hospital chose to willfully ignore that guidance and break that rule. Rockville General Hospital did not reconfigure and restart its gastroenterology surgery and procedure services, which it closed in March 2020, and for which it received a CON waiver. Therefore, on October 22nd, 2021, OHS started to assess a civil penalty of $1,000 a day. The evidence will show that 1 month after they received the explicit guidance from OHS saying that they should be back to pre-waiver conditions, RGH filed a determination with OHS because they believed no con is required to extend the waiver through the PHE, the public health emergency. Rockville General Hospital showed once again that they did not want to follow the rules given in the Executive Order 12B or in the latter guidance provided by OHS. On January 24th, 2022, OHS issued a determination stating that a CON is required to terminate a service, and RGH, Rockville General Hospital, cannot do so without approval in advance. This was another decision, another rule that RGH didn't like. And the evidence will show that the following day, CEO of Rockville General Hospital tried a new tactic, a personal email to the executive director of OHS asking again to change the rules. The executive director of OHS did not respond to her request. At the end of the day, the evidence will show that Rockville General Hospital did decide to resume surgical services on February 16th, 2022. So that is the last date OHS assessed the $1,000 a day civil penalty. In conclusion, the evidence will show that RGH, Rockville General Hospital, knew what the rules were and knowingly, willfully broke them. And the Office of Health Strategy should assess the $118,000 civil penalty as a consequence. Thank you.
Thank you. So we're going to now proceed to your evidence. Do you have any individuals here who are going to testify on behalf of the agency today?
Yes, I do. I have Steve Lazarus. He has submitted pre-filed testimony. He would also like to, I'd also like to have him testify briefly live today.
Okay. I also believe you identified Ron Sasonis. Is he going to be testifying as well today?
No, he is not. We decided not to call him today.
Okay, thank you. Mr. Lazarus, would you mind spelling your name for the record, please?
Sure. My name is Stephen Lazarus, STEVEN LAZARUS.
Okay, thank you very much. I am going to swear you in now at this time. Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you provided in your pre-file and the evidence that you shall give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. And do you adopt your pre-file testimony as your testimony here today?
I adopt my pre-file testimony.
Thank you. So Ms. Manzione, you can proceed.
Okay, thank
Yeah.
you. Just a few questions just to give us a flavor of your testimony. So Steve, would you tell us a little bit about your work history?
Sure. I've worked with Office of Health Strategy and its predecessor agency for approximately 26 years, through the different iterations of OHS, if you want to call that. I started off as a healthcare analyst, as I actually was a Connecticut career trainee, moved up to associate, principal, and currently I'm working as the operations manager for OHS. And I report to Kimberly Martone, who's the deputy director of the agency.
And did you say you work with the CON unit now?
I oversee the CON unit currently as an acting supervisor for the program. I also have other duties as part of the operations manager. I run some of the work groups I have over the past few years. I also oversee the various OHS portals and to make sure they're running well. And I work with the IT to ensure that everything is running tip-top, as well as if there's any upgrades that might be needed.
Perfect. Okay. Tell us what it was like at OHS when COVID-19 first hit back in March of 2020.
Well, I think like most places, we were working normally until we heard about this virus that was sort of spreading around the world and ended up, coming to our doorsteps. And at that point, we were directed to work from home. And luckily, we had the technology to be able to transition to that without much of an issue. And since then, we've actually been working from home majority of the time. We were able to continue to process our applications, hold public hearings and other things, just everything electronically via Zoom or Teams.
Okay. And what was the first you became aware of Rockville General Hospital's efforts or interest in getting any kind of waiver having to do with any of their services?
Well, I believe it was the waiver request that was filed with OHS as part of the new waiver form that we had developed based on the Executive Order 7B. And that, I believe, was filed on March 24th, 2021. Or was it 2020?
Okay. And just for the record, Hearing Officer Achuka noted that that docket number was 20-32361-CON-W. Okay, and so that was submitted. And do you know what happened to that waiver request?
Process-wise, if I look at it, it was the following day. It was reviewed by OHS, and on March 25th, 2020, it was approved and uploaded to the CON portal.
Okay. And what happened next?
As far as Rockville General Hospital, I believe the following the Executive Order 12, it was 12B. It was then there was a guidance that was issued by OHS in October 2020 on 2021. And following that, there was a determination filed by Rockville General Hospital on November 22nd, requesting to be able to continue the suspension of the services. I believe that was under 21-32508-DTR.
Okay, and you packed a lot of things in there. Just start with the Executive Order 12B. What, in your understanding, what happened? What is the purpose, or what did Executive Order 12B do?
It's my understanding, and actually, I'm not an attorney, so I didn't interpret it, but it was basically the one that actually ended Executive Order 7B that initially allowed hospitals to waive their current services to focus on COVID-19. And I believe that ended those services to resume on July 1st, which would be end of June 30th, 2021.
Yeah, I'm going to object to that, just for the record. I'm happy to do my objection, but I want it noted. Your interpretation of the executive order. I'm happy to read that section of the executive order into the record, but I'm not going to object to Mr. Lazarus's recitation and understanding.
Thank you. I'll sustain the objection.
Okay, we'll move on. So after the Executive Order 12B, what did the Office of Health Strategy do?
There was a guidance that was issued on 10/22/21, clarifying what was in the Executive Order 12.
And do you recall what the guidance document stated?
It generally stated the clarifying when the executive order 7B ended and when to resume services that were temporarily allowed to waive under executive order 7B.
Okay. And so do you know how Rockville General Hospital reacted to the receipt of that guidance document in October, if at all?
In October, there, I believe there was, I just look at my notes here, my testimony. I believe the next step that was actually put in place was, I don't know how Rockville General actually reacted in October, but I do know that they had filed a determination in November of 2021.
And can you tell us a little bit about what is a determination for in general? What is that process used for?
So CON determination process is a little different than the CON application process. It's basically where petitioner can request whether they need a certificate of need for something or not. And that's really what's determined, whether office would approve or not approve their request under CON determination process.
And how many determinations would you say the Office of Health Strategy gets in a year, for example?
We average approximately 50 CON determinations per year.
And what percentage approximately would you say result in an answer of no CON required versus CON required?
My guess would be around 10%, maybe about 5 per year, but that's hard to tell depending on the year and the type of determination, but generally probably about 5.
So the percentage that would require a CON as a result of a determination letter would be about 10%. So it's a pretty small number.
Of the overall determination filed, yes.
Okay. And what, if you know, was the outcome of the determination request submitted by Rockville General Hospital under docket number 21-32508-DTR?
On January 24th, 2022, their request for the CON determination was denied, and yes, their request was denied to continue the suspension of services.
So is that the same as meaning that a CON is required?
Yes, a CON would have been required.
Okay. And so what happened after that?
It is, according to the record, I mean, there was a civil penalty that was assessed on February 16th, 2022 by OHS.
Okay. And do you remember anything else? Do you remember any other interactions that you might have heard about?
The only other one, the only thing that I know of or heard of was there was an email that was sent from the CEO of Rockville General Hospital to Vicky Valtry, our executive director, that was also put into the record, which was requesting her to reevaluate the determination or her position and allow them to continue.
Is it usual to put emails into the record?
Yes, anything that comes in for a record, that typically goes to either the executive director or anybody in CON leadership would end up in the record that it's supposed to go into. That's the original file.
And do you remember any of the content of the message in the email?
Why, generally I remember, from what I remember reading it at the time, was that it was talking about requesting the executive director to reconsider the position and also allow them to continue the suspension of services.
Okay. Thank you. And do you know if the services have been restarted at Rockville General Hospital?
At this point, I don't know. I do believe they were started perhaps at a later date.
But you don't know.
I do not know directly. No.
Okay. And do you know if OHS has instituted or has assessed penalties against hospitals or healthcare facilities for violating CON laws in the past?
I believe they have. I don't remember specifically at the moment, but yes.
Okay. Those are all the questions I have for Steve today.
Okay, thank you very much. So I am going to allow cross-examination, and then Ms. Manzone, if you have any redirect on the cross, that's fine as well. So Ms. Volpe, do you have any cross-examination of Mr. Lazarus?
Yes, I do.
Okay, thank you. You can proceed then.
It's Michelle Volpe, legal counsel for Rockville. Steve, how are you doing today?
I'm well, thank you, Michelle.
All right, good. I'm glad. Steve, you just testified that if a party is uncertain whether they need a CON, what is it that they seek from the Office of Health Strategy?
Well, they would submit something called the CON determination,
Okay.
and which would lay out all the facts that the OHS would then review.
So it's a formal process, correct?
Yes.
And in that process, when we submit the facts and we send in the determination form, what does OHS do?
It's initially it's uploaded into the portal. It's assigned a docket number, and then it's reviewed by OHS staff. It's also reviewed from the legal point of view, and then ultimately the decision is made by the executive director.
So OHS issues a written response to that
Yes.
request on whether a party or a hospital needs a CON to move forward. You testified it's an official position of OHS as to whether or not a CON is required for these specific facts.
Yes.
And you also testified that it's your understanding that Rockville received a written determination CON response.
Yes.
And do you recall what our response said specifically? Because as Attorney Manzione said in her opening statement, words matter. So the words matter. Do you have the table of record in front of you?
I don't have the table of record, but I can bring it up.
If you can bring it up, and if you can look at date stamp 000076, That's the determination that Rockville received. It's determination 21-32508 DTR. It's already been entered into the record. Let me know when you're ready, Steve.
Sure. The computer's running a little slow.
No worries.
I'm sorry, Ms. Volpe, which exhibit were you looking at?
The November, the result of the determination that we received in response to our submission in November, the January 24th, 2022 OHS determination.
Yeah, I was looking for where in this hearing record we would find that. Is that exhibit somewhere in Exhibit H?
Yeah, and it's on a bait stamp under the table of record. If you have it, it's easy to refer to. It's part of our submissions under the table of record. Listen, in the interest of time, I'm happy to read what OHS's words are, if
Sure.
I may be permitted. OHS's words, and we understand the words are important, and the rules which we followed.
I would actually prefer, I'm having trouble finding the document. You refer to the table of record. Are you referring to OHS's table of record?
Yes, the table of record and the submission in the record and the bait stamp usually helps locate it. It's attached to our filing under, it's Exhibit H.
That's what I was asking, which,
Yeah, Exhibit H.
so in Exhibit H, which Bates number are you looking at?
000076.
Okay.
It's
I'm
an
almost there.
Mr. Lazarus, do you have access to that right now?
I do. I'm just scrolling down to that page.
I'm sorry, Ms. Volpe, it's just, I was having trouble, I knew it was in the record, I was just having trouble finding it myself, so I knew Mr. Lazarus was probably also having difficulty.
No worries.
Okay, I'm there now.
Okay. And Steve, can you
Yes.
read, can you please read for everyone the very last line of the OHS decision? Starting with therefore.
That's on page 76, right? The very last line.
The very last line, correct, of the decision.
Therefore, should the petitioner wish to formally terminate these services, a CON is required.
Very good, thank you. And so, as Attorney Manzione stated in her opening remarks, she said, we commence services. Is that what she stated? Is that what you heard?
I don't recall exactly the actual words.
She stated that we commence services. So,
Okay.
so a CON is required following the rules and the statute. A CON is required in this instance if we terminated services, correct?
That's what it says, yes.
Okay. So based on your statement before that a party can rely on a determination, which Rockville received from OHS, based on that statement, would we be required to file a CON?
I'm not sure if I have the expertise to interpret that determination, but I can I mean, it states what it states.
And what does it state in that last line?
It says, therefore, should the petitioner wish to formally terminate these services, a CON is required.
Okay. All right, very good. I have no further questions for Mr. Lazarus.
Okay, thank you, Ms. Volpe. Ms. Manzione, did you have any redirect for Mr. Lazarus?
No, I don't have any redirect.
Okay. I did have a couple questions for you, Ms. Lazarus, Mr. Lazarus, excuse me. So I believe you just stated that the executive director makes decisions on determinations. Is that correct?
Yes, or she can, I think she normally has a written permission. She defers it to Kimberly Martin, who's the deputy director, who actually signs the determinations.
Okay. The reason I asked that question was we were just referring to Bates stamp 76, and I scrolled to the second page and it had Ms. Martone's name and not Ms. Veltry's name.
Yes, no, yes.
And there was also one other question I had for you, maybe two. In the pre-file testimony that you submitted, you stated something along the lines of, or you quoted Ms. Weymouth's email to Ms. Veltry. Do you recall that in your pre-file?
Yes, I do.
And you said, you stated in your pre-file that she stated OHS is demanding a heavy lift that DPH / community need / reality of staffing available does not support. And then you wrote, I believe that that's the only hospital that used that reasoning. Most of the other hospitals and facilities are facing the same challenges, staffing issues, but they seemed to be able to continue services.
Yes.
Can you provide more specifics for me about what other hospitals and facilities you're referencing are doing, or what reasoning you provided?
Sure. I was just saying that, you know, this was the reason that was asked by Rockville General, that was provided by Rockville General Hospital. But other hospitals, if you look at the remaining hospitals, they seem to be, these issues appear to be general in nature, not specific to one place. At least that was my interpretation. And, you know, other hospitals were able to continue and resume services.
Okay.
I think that.
I think those were the clarifying questions that I wanted to have answered. So thank you. I appreciate that. And I appreciate your time.
Oh, you're welcome.
So now we can move on to the respondent's opening statement. Ms. Volpe, do you have an opening statement you'd like to make?
Yes, I do. Thank you. So we heard this morning from OHS that their assertion that Rockville did not follow the rules, and nothing can be further from the truth. And when we talk about the rules have to apply to everyone, and they have to be a level playing field. And the rules in this matter precisely are the CON statutes and when and under what circumstances a civil penalty can be assessed. So following those rules, you have to be in a position to have been required to file a CON to violate the statute. We just heard that Rockville has not terminated services. And under the statute, that is the only thing that gets implicated for not complying with the rules, the CON statute. You're required to seek a CON if you terminate a service. OHS's own counsel has acknowledged that we did not terminate a service. So there's been no service terminated, therefore the CON statute doesn't get invoked, therefore there's no requirement for us to file a CON. That's the first part of the rule, but there's two parts to this rule. The second part is that we had to act, Rockville had to do all of this willfully, recklessly, not in compliance, in such an egregious manner that we're required to be fined. How, in following the rules, by seeking a formal waiver, which the waiver stated by its own terms, we were allowed to suspend services through the public health emergency. That was what Rockville understood to be the facts. Suspend services through the public health emergency, which is precisely what was done. Public health emergency has been extended numerous times. At that time period in which their understanding was, is that the public health emergency was going to expire on February 16th. They implemented those services pursuant to a formal waiver and decision from OHS that said you can suspend services through the public health emergency. If we turn to the specific words, because the words are important, they're OHS's words. If we turn to OHS's words, it says right in the waiver, you're entitled to suspend services through the public health emergency. Should you wish to terminate, formally terminate, permanently terminate after the public health emergency, you would need to be required to seek a CON to terminate those services. So that's an important word that we need to pay attention to in interpretation. How could Rockville have willfully violated the rules when we went and followed OHS's rules, which were to file a formal waiver determination, which we did? Okay, let's fast forward to October. Rockville General Hospital, Ms. Deborah Weymouth is under oath before the Office of Health Strategy, under oath, testifying under oath that her understanding was she had through the public health emergency to implement services. That was after the executive orders were issued. And we take issue with, and that's why I objected, and I apologize, Steve, to having to object. We object to your reading and your understanding of the executive order. Lots of people's understanding, including my client's understanding of the executive order, was that Executive Director Veltri's authority expired with that order, but not formal decisions that were issued by your Office of Health Strategy. It was her ability to make new rules and change the rules. That's what expired. So what does my client do? I think there was a question, Attorney Manzione asked Mr. Lazarus, what did Rockville do during that time period of October? I'm not sure how you would know, but let me tell you what we did. What Rockville did was they got this bulletin, which yes, they were aware of the bulletin, and they're like, wow, how do we reconcile this? This makes no sense to us. Our specific waiver said we had through the public health emergency. Oh, you know what? What do I do? We sought out, talked to the Connecticut Hospital Association, called legal counsel. What do we do? Well, what do you do when you're unsure whether or not you need a CON? You file a determination. That's precisely what Rockville did. How can it be even suggested that they were usurping the CON laws when we followed the very rules, which are important, which say if you're unsure whether you need a CON, file a determination. That's precisely what we did. And we get back our determination in January, okay? After we filed it in November, that whole time period. What are we doing? We're marching along, figuring out what needs to be done to get these services safely implemented at the hospital. There's a lot that gets involved. It was stated today, healthcare is a highly regulated industry. Yes, it is. And since COVID, it's become even more so. So what does the hospital do? It spends days and weeks planning on how it's going to implement these services safely. That's what was done during this entire time period. And we all know, because Mr. Lazarus read for us, what did that determination say? It said, if you're going to terminate, you need a CON. So let's bring us back, okay? What you've heard from OHS today and the remarks that were made do not support nor rise to the level of a civil penalty, and the penalty should be rescinded. OHS, by the way, has the burden of proof, and they need to show that we needed a CON, that we violated the CON statutes, we needed a CON. It's been established we did not. They also have to show, to make us pay a civil penalty or impose it, that we did so willfully. We decided just flippant, we're not going to follow the rules. Again, not true. OHS has not put forward any facts, evidence, or law to support the imposition of a civil penalty against Rockville. Although OHS, again, has the burden of proof, it has been Rockville that has filed and set out in detail through its legal briefs, pre-file testimony, rebuttal testimony, as well as the testimony you're going to hear today, hundreds of pages as to why there is nothing in the docket or the proceedings that support the imposition of a civil penalty against Rockville. Again, the rules we're following are the statutes that have been made by the legislature. Those are the rules. Our submission includes nearly 200 pages of evidence and testimony that completely refute OHS' position that Rockville be assessed a civil penalty. Essentially, that Rockville didn't follow the rules of the law. The facts, the filings, the timeline, the testimony speak for themselves. There's overwhelming evidence that the assessment as a civil penalty is completely unwarranted. Not only does OHS have the burden of proof, but their burden is a high one, okay? It's at a minimum by a preponderance of the evidence. It's at a minimum, they have to show that we acted willfully. It means, as a matter of law, the OHS has to prove many things before they can say a civil penalty is owed. We talked about the primary two reasons and elements that they have to prove. They have to prove that Rockville was required to obtain a CON, and they have to prove that we acted willfully in failing to seek a CON. The fact that we filed a determination that stated we didn't need a CON unless we were terminating services, that is what has to be looked at. That is the operative evidence. Nothing can be further from the truth that this matter, that we usurp the CON statutes. The facts don't support that finding. What does this all mean legally? It means, like we stated, OHS has to prove by at least a preponderance of the evidence that we didn't follow the law. Again, why would Rockville have to file a CON? We would only have to file a CON if we terminated services at issue, which we did not. OHS has to prove that we formally and permanently, those are their words, and we heard that the words are important, that we formally and permanently terminate services. We have not. Those specific words must guide OHS in its decisions. We found that those are your words, those are OHS's words, not Rockville's words. The services were in fact suspended during a once-in-a-lifetime global pandemic where millions of Americans have died, where the country was experiencing a national healthcare worker shortage, and Connecticut was in the midst of a behavioral health crisis. We haven't heard anything about that, but there's a lot today, but there's a lot in the docket. What was going on at Rockville during the time period that OHS was investigating us, looking to impose civil penalties? What was going on? I'll tell you what was going on. Rockville and Manchester ECHN network was probably the only, if not the only, hospital to step up when all the state agencies were looking for help to address a dire need, a crisis that was occurring in Connecticut for children with behavioral health needs. That's what we were doing. We were determining how can we rearrange what we have going on to open up beds specifically for adolescents. We were doing that in conjunction with OHS, unbeknownst to us that they were investigating us. We were doing that in conjunction with the Department of Public Health. Rockville was doing that in conjunction with the Department of Social Services. We were working with all these agencies on how could we step up and fill a dire crisis need for behavioral health services for children. That's what was going on then. So the services were suspended that were pursuant to the waiver. Those surgical services, those GI procedures, we're not contesting that. We're not refuting that. They were suspended. So were they for many other hospitals. To address, the point on the email, yes, of course, the president of the hospital reached out to the executive director. Why? Because it was unconscionable that they're saying you need to immediately accelerate your implementation that was planned for February 16th. January 24th, you have to immediately implement. Doesn't make sense. We know healthcare is highly regulated. We know it takes a lot to implement a service. We were marching along ready to implement that service, which by the way was not terminated, which was in fact implemented on February 16th. Rockville has testified and understood that a CON would only be required if it were to formally and permanently terminate the services. Rockville followed the rules. They received a waiver. They relied on the waiver. They relied on the words in the waiver that stated that their services could be suspended through the public health emergency. We got new guidance, by the way, that showed up from the Office of Health Strategy months after the executive order that said, implement automatically, implement immediately. We're like, what does that mean? We have a waiver issued, a formal position that allows us to suspend services through the public health emergency. So what do? We follow the rules. We submit a determination. We ask you, what does that mean? You're not saying that the law doesn't require a CON for a suspension of services. That's not what you're saying, right? And you answered, right, that's not what we're saying. We're saying if you're gonna formally terminate, you need a CON. Rockville did not terminate the service. Second, it did not act willfully in disregard for the law. There is testimony under oath by Ms. Weymouth as far back as last October and as recent as this week in the rebuttal stating that Rockville understood, that's an important word, understood and believed it had until February 16th to re-implement services. As important, these services have not been terminated, they were implemented, so a CON is not required, so we don't even trigger the civil penalty statutes. Rockville did not violate the CON statutes, and it certainly did not act in any manner to usurp the CON laws. The only conclusion any reasonable trier of fact can arrive at is that civil money penalties must be rescinded. Let's keep in mind, to impose a civil penalty under the Connecticut statutes, OHS must find that a CON was required. That's the first prong. The second element is that Rockville willfully failed to file a CON application. Again, when do you have to file a CON? When you terminate a service. There is nothing in the statutes or the regulations or even in OHS's own precedent that indicates that a temporary suspension versus a total termination or elimination of services requires a CON. In fact, the waiver approval response from OHS specifically advised Rockville that the temporary suspension of services was not a termination of service. Termination of service is a prerequisite for a CON being required, and I'm going to quote the statute that OHS counsel quoted, 19A 638A5. That's the statute. That's the operative rules. Termination is not defined in the statute, not the present statute. Absent of finding that a services were terminated, there is no obligation to file a CON and no willful failure. Let's talk about what it means to be willful, because we haven't really heard a lot of that today. To be willful, we have to understand that we're doing something wrong and we're intending to do it and we're acting recklessly in doing it. Under Connecticut law, whether conduct is willful is based on the state of mind of the actor. Whether a party engaged in willful, wanton, or reckless conduct cannot be determined simply by asserting if a policy has been violated or it hasn't been followed. Willful means it requires a determination that you had the intent to violate that policy, none of which existed in this matter. How could we have intended to violate the statute when we followed the very rules that OHS set out? Connecticut case law holds that a misunderstanding or a good faith dispute does not constitute willfulness. Again, we got to follow Connecticut law. We got to follow the statutes. We should follow the case law. A good faith dispute or a legitimate misunderstanding about the mandates of an order preclude a finding of willfulness. There's lots of case law that state that. We've cited in our brief. That's all in the table of record. Rockville never acted willfully. Rockville believed in good faith that no CON was required to continue the suspension of services during the public health emergency. We stated that under oath. In addition, as evidenced by Rockville's conduct in filing the November determination, again, following your rules, OHS cannot find that Rockville understood a CON was required. If we thought a CON was required, why did we file the determination, the very filing that you do to ask if a determination, if a CON is required? Again, Rockville acted with complete transparency, availed itself of every means offered by OHS to ensure compliance. Every formal means through the waiver and the determination, and yes, every informal means by reaching out directly to the executive director who had been collaborating with the president of the hospital on the behavioral health needs. It's only natural that two senior people discuss, do you really, we're not terminating, right? So we're implementing in a few weeks. We can't implement immediately safely. That would jeopardize patients. That's not good practice. That's not what the Department of Public Health would want. So Rockville did not believe a CON was required because it did not and formally terminate a service, and therefore it never acted willfully or reckless in disregard for the CON laws. Without intent, there can be no willful failure, and without a willful failure to comply with the CON laws, there can be no civil penalty. So I'd like to introduce Ms. Deborah Weymouth. She's president of Rockville General Hospital. She's here today to adopt her pre-file testimony and to add additional support to what the hospital understood it was required to do during a once-in-a-lifetime global pandemic. Ms. Weymouth.
Thank you, Ms. Volpe. Ms. Weymouth, would you please spell your name for the record, please?
Sure. Deborah Weymouth, Deborah, Weymouth, Weymouth.
Okay, thank you for coming today. And now I will swear you in. Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give in this case shall be the truth, the whole truth, and nothing but the truth? So help you God, or upon penalty of perjury?
I do.
Thank you. And do you adopt your pre-file testimony?
I do adopt my pre-file testimony.
Thank you very much. Ms. Volpe, it sounds like you have either some questions for her, or Ms. Weymouth, you wanted to present a statement. So proceed however you would like at this point.
Thank you. We appreciate that. Ms. Weymouth would like to make a few remarks.
Okay.
Thank you. As stated, my name is Deborah Weymouth, and I'm the Chief Executive Officer of Eastern Connecticut Health Network, which operates Rockville General Hospital. When COVID-19 hit us all in early 2020, every hospital and healthcare facility had to rapidly adjust. Rockville Hospital was no exception. This worldwide pandemic that now has taken the lives of over 1 million people in the United States alone required only the declaration of the public health emergency, not only the declaration of the public health emergency, but also an adjustment to constantly changing guidance and expert input. One of those adjustments was to suspend the GI and surgical services at Rockville. This was only a suspension. Rockville Hospital is now back performing GI and surgical services. There has been no permanent or formal termination of GI or surgical services at Rockville. Rockville was always in compliance with the CON statutes, as the CON statutes only address termination of hospital services. It was represented before OHS formally and informally that Rockville would be resuming services on February 16th, 2022. And in fact, Rockville commenced implementation of suspended services on February 16th, 2022, just as it stated it would. Further, Rockville always believed it maintained compliance with the CON statute. We never understood we needed a CON to suspend services. The statute and the determinations Rockville General received all specifically reference a formal termination of services and not a temporary suspension. We believed and still believe that we complied with the CON law and certainly never intended to usurp the CON requirements. In fact, we engaged in countless measures to ensure continued compliance, acted with full transparency and with regular communication with OHS. OHS has honed in on one phase in my email I sent to Commissioner Veltri, that this would be a quote unquote heavy lift. First, please note that this email came about as a result of several attempts to reach the commissioner by phone. Neither my phone calls nor my email received the courtesy of a response. Further, this statement must be read in context with the rest of the email and the various avenues that Rockville pursued. At the time of the issuance of the January 24th determination, we were dealing with the height of the Omicron surge, tremendous staffing shortages, and we were months into planning the opening of a new adolescent behavioral health unit to help alleviate the dire pediatric behavioral health crisis that was going on in the state. This was an urgent need for children, with extensive related media coverage, and various state agencies had rightfully made this a priority. There were numerous calls and Zoom meetings with state leadership and CCMC to share this information and obtain their agreement on ECHN's path. ECHN was the first and one of the only providers who made this decision at the height of the third wave of COVID, a significant healthcare shortages to open and staff additional inpatient behavioral health beds. Even with the nationwide healthcare worker shortage, with ECHN having up to 150 of its regular employees out with COVID, a mass ECHN provider retirement, along with many other obstacles, ECHN still opened the 10-bed unit and still actively planned on the resumption of GI and surgical services at Rockville for February 16th on 2022, as it had always done. At this same time, unbeknownst to us, OHS was actively investigating us and running up our fines and issued a determination that would have us resume services 3 weeks before the planned date. At that moment, yes, OHS was indeed imposing a heavy lift with immediate resumption. As I testified, our intention was always to reopen our suspended services at RGH, and we have done so. We did not willfully fail to file a CON, as we were confident no CON was required based on what we understood as the law, the guidance, and the waiver that we received from OHS. It is our position that we complied with the CON laws. For the reasons set forth in all of the filings and in my statements under oath today, we respectfully request that OHS waive this civil penalty. Thank you.
Thank you, Ms. Weymouth. Ms. Volpe, did you want to do any direct examination of your witness at this time?
Well, I'd like to see if Attorney Manzione is going to present any cross and then have the opportunity to redirect.
Okay, that's fine with me. Ms. Manzione, do you have any cross-examination?
Just 1 minute, please. No, I don't have any cross-examination.
Okay.
If there's no cross, then I would like to have this opportunity to pose some direct, just as Attorney Manzione did for Mr. Lazarus.
Certainly, that's fine with me.
Okay, thank you. How are you doing, Ms. Weymouth?
I'm great, Ms. Volpe.
All right, good, I'm glad. Did you?
And I'd like to retain my ability to impose cross after this, because there might be new evidence that comes up.
Okay, thank you.
Did you testify under oath at an OHS CON hearing on October 13th, 2021, that Rockville was planning to resume surgical and procedural services upon the expiration of the public health emergency?
Yes,
For the record, that testimony is in the table of record. And if need be, we can cite to it or read to it, but it's entered in as evidence in the table of record, the sworn testimony by Ms. Weymouth. Based on that testimony.
I believe it's an excerpt, right? Not the full testimony.
Correct. It's
Okay.
not the full testimony, and it's from the docket that you took administrative notice on, which
Okay,
is the.
thank you.
Thank you. Based on that testimony, which you made under oath, you believe the hospital had through the public health emergency to suspend services, correct?
yes,
And did you continually assess when the public health emergency expiration date was?
yes.
And what did you understand you would be required to implement? What day?
February 16th, the day the public health emergency was due to expire.
Okay, thank you. And after your testimony, OHS issued a bulletin on the expiration of COVID waivers. This is the bulletin that was referenced today by OHS counsel that was filed on October 22nd, 2021. What did you do when you became aware of that bulletin issued by OHS days after your own testimony? What did you do? I know OHS counsel had asked that of Mr. Lazarus, but let's hear from you. What did you do?
I reached out to CHA, the Connecticut Hospital Association, for direction and questioned, as CHA has regular meetings with OHS, and they raised this issue along with others. I know they raised this issue on one of the calls, but it was my understanding that there was no definitive agreement on what our Rockville General should do.
Okay. And so since there wasn't any definitive agreement, you were still unsure. What did you do next?
I reached out to legal counsel.
Okay. And what was the outcome of reaching out to CHA and legal counsel? What did you decide?
Well, both legal counsel and CHA recommended we request a determination from OHS. As my understanding was that Rockville had, through the public health emergency, as we already had a determination, and I understood that we could rely on. And that was inconsistent with the bulletin, and it was unclear which one took precedent.
Okay. So after that, what did you do? Since you were uncertain, it wasn't clear, you thought you were following the rules?
We filed a CON determination.
And that was the determination that's already been referenced numerous times today in November of 22nd, 2021.
Yes.
And what did you do when you were waiting months to hear from OHS? What did you do?
Well, we continued our internal planning that had started earlier in the fall. We were implementing all the logistical aspects that are required for re-implementing or reopening a service.
And what's involved in that re-implementing, resumption of services? What?
Well, there's a lot of work to be done. Given the provider retirements and the staffing shortages, we had a number of meetings. We tracked our progress. We had site visits. We reached out to providers. We reviewed our physical plant and so forth. This was all being done at the same time that we were dedicating significant resources to opening the 10-bed adolescent behavioral health unit.
And when did Rockville perform its first procedure that was suspended pursuant to the waiver?
February 16th, 2022.
So after you received the determination on January 24th regarding OHS's position on the suspension of services, what did you do next?
Well, I called Victoria Veltri and then eventually emailed her because my calls went unanswered. She also did not respond to my email.
And why did you email her? I understand you just testified because you didn't get a response to your calls, but why were you persistent, working on making sure we were compliant? What was going on?
Based on our understanding of the law and the OHS guidance, we still did not feel that a CON was required because we were not terminating services. And we wanted to re-implement them after the public health emergency and then reassess. And I wanted to reiterate our position and give OHS a real-time update on the hurdles in starting our most recent service, that 10-bed adolescent behavioral health unit. This was a priority for the state and for DPH, and we have been working towards bringing these beds into service at request of the state.
I have no additional questions for Ms. Weymouth, but I also would like the opportunity to redirect if Attorney Manzione has any questions.
Okay, that's fine. Ms. Manzione, do you have anything?
Yes, yes, I do. Thank you. I want to make sure I have the right document that I'm referring to. Good morning, Ms. Weymouth. It's still morning, right? Yes,
Yes, it
it is.
is.
Good morning. Okay, just a couple questions. When we're talking about the guidance document that was issued by OHS in October, I think it was October 22nd of 2021, you said, you just testified that you reached out to CHA and also to your legal counsel. Is the legal counsel, is that in-house legal counsel or is that outside counsel?
It's outside counsel. I spoke to Ms. Volpe.
Okay. And when you say you reached out to CHA, can you tell me a little bit more about that?
The Connecticut Hospital Association?
Yeah, who did you reach out to? What happened? How did you reach out to them? Why did you reach out to them?
So the Connecticut Hospital Association exists to support the hospitals in the state of Connecticut, as you're well aware. And often they connect with elected officials and regulatory bodies and provide us information that is helpful. Knowing that they have this data, I utilize them as a resource.
And so, was there a particular person at the Connecticut Hospital Association you reached out to?
No, not in particular. There are several people who are involved in this process.
But nobody you remember at this time?
That's correct.
Okay. And do you remember any specific information that you received from the Hospital Association regarding this guidance document that was issued by OHS in October of 2021?
No.
Do you remember asking questions of the Hospital Association saying something to the effect of, have you gotten questions from any other hospitals about this?
I'm sorry, could you restate that for me?
Sure. So when you spoke to a person at the hospital, Connecticut Hospital Association,
Right.
did you possibly ask something along the lines of, have you heard from other hospitals about this guidance document that OHS issued? What have you heard?
I don't recall exactly.
Okay. Do you recall anything from the Connecticut Hospital Association where the representative you spoke to said, this is a crazy document that the OHS filed or issued, something along those lines?
No.
Insert your words are crazy, ridiculous, unnecessary, confusing. Was any characterization?
So, as I said, Connecticut Hospital Association exists to provide us advice and support the hospitals in the state of Connecticut. You know, I don't recall them using those types of words, no.
So did the Connecticut Hospital Association suggest to you that this would be an important document from the state regulator that you should take seriously and follow? maybe that's a compound question. Let me break that down. Did the person you spoke to at the Connecticut Hospital Association say, this is an important document that was issued by the state regulator?
The persons that I spoke to at Connecticut Hospital Association suggested that I call Commissioner Veltri for clarification and for understanding and to work together as professionals.
Okay, so you reached out to the Hospital Association, I would say I'm guessing shortly after the guidance was issued in October of 2021. And so that meant the Hospital Association representative suggested that you reach out to Executive Director Veltri soon. Is that what you're testifying to?
Yeah.
I'm just trying to understand what your timeline is, because I know that you said you called and you didn't get any response and you emailed, but that was in January of 2022 after you received the determination request. I'm wondering if you tried sooner, closer in time to the October guidance letter.
So we filed the determination, if you recall, at that point in time in November, and heard nothing for an extended period of time until January. And obviously, time causes one to say, you know, where is our response? What's happening? I would also like to point out that I am in regular contact with the Connecticut Hospital Association. I'm actually currently a board member there. So I chat with them on a regular basis. So it's not a one-time communication. There's always regular updates on what's happening legislatively and things that we need to be aware of as hospital providers in the state of Connecticut.
So as a board member, were you a board member back in October of 2021?
No,
Of the Connecticut? No. Did the Connecticut Hospital Association have board meetings monthly, or for example?
they have
In-person
regular
or
meetings,
Zoom?
right, but I just became a board member in 2022.
Okay.
I was involved, but
So what I'm trying to get at is, was the topic of the guidance document or regulations, questions about regulations, a topic of discussion in front of the Connecticut Hospital Association in the fall of 2021?
as I stated, all regulatory issues are topics of conversation at the Connecticut Hospital Association. All the time.
Okay, and do you recall any specific conversation about this guidance document?
No,
Do you recall any other hospitals receiving this guidance document or telling you they've received the guidance document?
I understood that the hospitals throughout the state of Connecticut had received the guidance document.
And were they as surprised by the guidance document or confused by the document?
I'm going to object to Ms. Weymouth testifying about the reactions of other presidents and executives of other hospitals on their position to the OHS guidance waiver.
The reason I'm asking this,
Ms. Manzone, I was just going to suggest that you try to rephrase the question. I think it could be asked in a way that is not objectionable, but
sure. Okay. Ms.
or
Weymouth,
if
I'm
you
trying
want
to
to
get
move
at,
on, that's fine too. It's
Right.
your choice.
I will wrap this up. I'm just trying to get at the, I understand if you, I understand your testimony so far was that you received let's see, and in your rebuttal testimony to our witness, Mr. Lazarus's testimony, that there was a lot of confusing information around that it was not clear to everyone what the impact of the Executive Order 12B was, and it was further muddied, perhaps is one way to describe it, by the issuance of this guidance document from OHS that was issued in October of 2021. You reached out to legal counsel, understandable. That's your personal resource, makes a lot of sense. And you reached out to an industry association, the Connecticut Hospital Association, who has connections and hopefully the ear of lots of the other hospitals and possibly the regulators. I'm trying to get at, did they give you any clarity? And did they encourage you to do any particular actions? I'm not sure that I got an answer to that. But what you did do, or what the hospital did do, was file a determination request in October. So I'm wondering if in between the guidance document, the receipt of the guidance document.
Just for the record, there's a lot of testifying going on right now and not a question. So
Here's the question. So between October of 2021 and November 22nd of 2021, did Ms. Weymouth, did you reach out to OHS by telephone or by email to any person at OHS to ask for clarification?
No, we filed our determination.
Okay. Okay, and after November 22nd, 2021, when you filed your request for a determination, and you were waiting for the results, did you communicate the fact that you were planning and re-implementing your services? Did you communicate all the work that you were doing to anyone at OHS, that you were doing all of this work? I saw a lot of documentation as part of the rebuttal testimony or the rebuttal evidence that was submitted in rebuttal to Mr. Lazarus's testimony. Did you communicate that in any way?
So we had filed the determination and we were waiting to hear back from OHS, expecting literally daily to get communication that we did not receive until nearly the end of January.
So did you communicate the fact that you had a lot of planning about re-implementing your services, that you had tracking logs, that you had lots of meetings going on, you had recruitment, you had site visits going, any and all of that information that you submitted as rebuttal evidence? Did you communicate that to anybody at OHS, perhaps as an attachment to your determination request?
Perhaps you could help me with the process for that. We knew the process was a letter of determination. I'm unfamiliar with how I would share internal documents of plans and implementation trackers that would go on to OHS for their review.
So it sounds like, no, you didn't.
Like
Is
I
that
said,
true?
please help me with the process of what I would have done other than to file a letter of determination to share that information.
Well, I'm just going to direct the witness to answer Ms. Manzione's question rather than asking another question in response.
So I want clarity on the question. Because we're trying to follow all of this. But is the question, did you informally reach out to OHS and tell them yes, our services are suspended. I think they knew. It was our understanding, we learn now, that you were investigating us. So you presumably you would have understood that we were looking to re-implement and we were engaged in this. During this time period in question, we were working very cooperatively with OHS on behavioral health services. So if there was any question, we received no questions on our determination. You know, I've submitted lots of determinations, and if OHS has a question on what we submit, they ask us a follow-up. They could have asked us, we submitted a formal determination. You could have asked us, what are you doing to re-implement suspended services? What are you doing? Nobody ever asked us. We hadn't heard from you in months, and we get a decision that says, if you're going to terminate, file a CON. So yes, I think we can answer. I think it's abundantly evident, and I can have Ms. Weymouth answer that. No, we did not produce trackers in our determination request, nor did OHS ask us to do that. You could have. You had, the executive director had the authority to permit suspended services. Prior to COVID, that was allowed all the time. During COVID, subsequent to COVID, a public health emergency, suspensions occur. You could have come to us and said, hey, look, you're asking for an extension of the waiver. I don't really feel I have authority to extend a waiver, but I certainly have authority to allow you to continue to suspend services. So yes, she could have said, show me what you're doing. What are you doing to advance this? You want to commence February 16th. What are you doing? So to answer your question, answer it. No, we did not produce trackers, nor were we asked for those at the time, which OHS could have asked us for those trackers.
Okay.
I'm going
so
to
the answer-
remind both of you that your testimony is not anything that I can use in making my decision. So, and it's not actually testimony at all. It's just statements of counsel.
So my answer is no.
Okay.
And I'm sorry, Laura, can you just state what the question was? I think we got pretty far off on what the actual question was.
Sure. So my question was, so after the determination request of November of 2021 was filed, and you were waiting for months for some kind of response that didn't come right away, did you at all communicate with OHS that you were planning on re-implementing services and that you actually had a very robust system, a plan, including tracking systems and plans and site visits and all sorts of things going on?
No.
Did you communicate any of that
No.
in any way? No. Okay. Thank you. Okay. And so just to close this loop, did OHS ask you any follow-up questions to your determination? Sometimes you'll get a letter of completeness request, clarifying questions like you would get sometimes in a full CON application, but sometimes you'll get them in a determination request. Did you receive any of those?
No.
Okay. Okay, that's the end of my cross-examination. Thank you very much.
Thank you. And Ms. Volpe, did you have any further redirect?
I do, actually. Ms. Weymouth, while you did not put in the trackers, you did put in the determination. And what does your determination, can you read right here what, I'm having her read from the determination that was submitted. It's base stamp 000071.
Despite the noted difficulties and the continued impact of COVID-19, Rockville is actively working to resume services that were temporarily suspended pursuant to the waiver. Resumption of services is planned on or before the expiration date of the public health emergency on or about February 15th, 2022.
Thank you. So that was an update. If OHS required further questions or documentation, they had the obligation to request the same.
Ms. Volpe, if you have a question, you're free to ask it, but please don't testify on
I have
behalf
no
of.
further questions. Thank you.
Okay. So Ms. Weymouth, I have a few clarifying questions of my own based on my review of what was submitted. Ms. Volpe, perhaps you can assist her with this. I just wanted her to take a look at Exhibit H, page 50, date stamp page 52.
Yes, let us pull it up.
Which specific document is that? Just so because I have it subdivided.
That's their original waiver form. It's page
Okay, thank
3
you.
of their waiver.
Got it. Thank you.
Yes,
We have it in front of us.
Okay. So in that first paragraph, it sounds like you were requesting a number of things be suspended. Sounds like operating rooms for elective and non-elective surgeries. Your specifically the GI procedure for elective and non-elective surgeries, the pre-op area, the post-anesthesia care unit area. Did those all come back online? Excuse me, effective February 16th?
on February 16th or shortly thereafter.
So can you provide some more information about that? Like when specifically certain procedures came back on and were the first dates that they were performed?
Sure, the 16th actually was, they're not spelled out here by number, so procedure rooms and so forth on the 16th, and on May 10th were the surgical services.
All right, sorry, so between February 16th and May 10th, what transpired? I'm sorry, just in terms of when things came.
Yeah, cases and procedures transpired at Rockville during that time.
So looking at that first paragraph of page 52, on page 52 of your submission, I'm just trying to figure out when each of those requests that you made were reversed. You said they weren't all February 16th.
Right.
So what was on February 16th that restarted?
Our GI procedures.
Okay. And it sounds like there were a number of other things that were suspended pursuant to this waiver. What else was restarted after February 16th?
So all of those things are actually under a title of perioperative services, and you utilize each one of those areas as you actually do a case. So they're not separate and distinct. You actually do those functional procedures as you go through the case on any given day. So they're not like separate rooms or floors or so forth.
So I think this has been described as the suspension or the termination of surgical services and procedures. Were there any other surgical services or procedures that were suspended pursuant to this waiver that were not restarted on February 16th.
Okay, so the process of implementing all the services is a process that does take time, because you have to have providers to, provide the various care functions. So as we have providers available, we offer that service. So the GI services started on the 16th, and as I said, others followed shortly thereafter.
Okay, I am trying to understand what shortly thereafter is, because if part of your argument is I should mitigate or I should rescind based on the fact that you restarted everything on February 16th. But now you're telling me that not everything restarted on February 16th.
So as I said, they are different processes as you go through a perioperative procedure. You have a pre-op area, a post-op area, you have the operating area, the procedure room, all of those all function together in providing perioperative care for the most part. So what I'm saying is that we reopened that service on February 16th.
Okay,
And that there was no termination of a service that exists, pursuant to the waiver.
okay. So everything was technically, and correct me if I'm wrong, but everything was technically reopened on February 16th, but certain procedures didn't take place immediately because it was dependent upon the availability of different doctors and things of that nature. Is that correct?
Yes.
Okay. I'm sorry to have belabored that. I just wasn't quite understanding what was going on, because in a number of spots it said that RGH has resumed certain services as of February 16th, but there were places, actually pretty much every time that was referenced, it said certain services. It didn't say all services. But what you're telling me is that all services resumed effective February 16th. It's just that some of them didn't begin taking place on February 16th.
Correct.
Okay. Another question, and certainly Michelle and Ms. Manzione, if you have any questions and follow up to anything that I'm asking, I'm happy to open up the floor to you to clarify anything as well. So in your rebuttal that was submitted a couple days ago, it seemed like the first meeting that took place, or at least the first document that was produced that suggested a meeting took place, that planning was being, okay, let me back up, I'm sorry. So the first document that I saw in your rebuttal that showed that a meeting took place where you were planning to restart these services was October 26th, 2021. Looks like it was Bates number 140. To the best of your knowledge, was that the first date that this planning to resume services began?
So it's the first documented date when it appears on an agenda or a tracking document. But those kind of conversations go on a regular basis here at ECHN.
Okay, that's what I was getting at. I wasn't sure if there's anything before that date or not. So thank you for answering that. And the last question I had for you was on Mr. Lazarus, or Ms. Volpe brought it up with Mr. Lazarus. It's Exhibit H. It's your exhibit, Bates number 76. So that is
What
our
document is that?
That's-
Just so,
OHS's decision on Rockville General's determination request.
okay, so it's
It's
their
page-
exhibit 6. Okay,
Yeah, it's page
I got
page
it.
3
Thank
of
you.
that.
Okay, the January 24th document.
So I am again going to focus on that last sentence of page 76. Do you see where I'm looking?
Yes,
Do you, in your mind, is there a difference between formal termination and termination?
no,
Okay. That was my only question on that. So Ms. Volpe, did you have any questions that you wanted to ask your witness based on my questioning?
No, nor do I think anyone else should, but no, I do not.
Okay. So I think we are going to, actually, one other question. I'm sorry, Ms. Weymouth, about your background. Do you have any formal legal training or education?
no.
Okay, thank you. I do have a couple questions for, actually, I have one question for the attorneys. I'm going to pose it, and then I am going to suggest that we take maybe a 10-minute break before we do final arguments, closing arguments. And the question is there a limit to which assessed penalties I can mitigate or waive? So if I determine that it was proper for the civil penalty to have been assessed, can I mitigate or waive it anyway, or am I compelled to let the civil penalty stand? So I'm just curious. I would like to hear from both of you on that question when we come back, and afterwards we can do closing arguments. Does that sound okay?
Sounds
Would
great.
you repeat? I'm sorry, I just want to make sure I understand. Would you repeat that question, please?
I guess it was two parts. The first one is there a limit to which assessed penalties I can mitigate or waive? And the second component is, if I determine that it was proper for the civil penalty to have been assessed under section 19A-653, can I mitigate or waive it anyway? Or am I compelled to let the civil penalty stand?
Yep. We'll be prepared to address that after the break.
Okay. Thank you. And certainly if you
and
feel
I'm
as though you'd like to address it in writing as well, that's fine, but it's sort of an informal question, so.
If you have it in writing, I would love it if you could put it in writing, either on the screen or
Sure.
in a chat, or email it to us. I
Yeah.
just want to make sure I get it right. It's kind of complicated.
I will
you.
email it to both of you. And let's, I guess, come back at 12:15. So give us 15 minutes. Does that sound okay?
That works for
Perfect.
us. Thank you.
Okay.
Thank you.
All right, so we are going to pause the video for 15 minutes and we'll come back at 12:15. Thank you very much. So we're going to proceed in the same order as we have been since the burden is on OHS. I'm going to ask that Ms. Manzione answers or responds to that question or questions that I sent you by email. Did you both receive those, the email?
I haven't checked
Yes.
my email, but I
Okay.
heard your question and wrote it down during the proceeding. So
Okay.
we're prepared to answer it.
Okay, thank you. Ms. Manzione, you can proceed.
Sure. Thank you. So you had two questions. The first was, is there a limit to which assessed penalties you can mitigate or waive? So under section 19A-653, I do not believe there is a limit to which assessed penalties you can mitigate or waive. The applicable section is 19A-653 subsection C. The middle, actually close to the end of the section, it says the Office of Health Strategy may mitigate or waive the penalty upon such terms and conditions as, in its discretion, it deems proper or necessary upon consideration of any extenuating factors or circumstances. So I think that you have a lot of discretion to do as you see fit based on whatever you think is appropriate.
Okay.
And if you determine that it is proper for the civil penalty to have been assessed, can you mitigate it or waive it anyway? Or are you compelled to let the civil penalty stand? No, I think you can mitigate it. I think you can waive it. And I do recall from my earlier research on hearings on civil penalty that in the past, hearing officers had conducted these kinds of proceedings and after taking testimony had decided to waive the fines or the penalties that had been imposed in more than one case. So I think that there's precedent for that. I don't have those cases handy, but I'm sure I can find them if that is something you would like. And similarly, you didn't ask this question, but if you choose to keep the penalty imposed, and if the respondent is not, it doesn't agree with that or is unhappy with that, they have the right to go for an appeal directly to the Judicial District of New Britain. So.
Okay.
That's
Ms. Volpe, I assume you're not going to be inconsistent with OHS's position, but I'll let you speak on the questions as well if you'd like.
I would, thank you. No, I absolutely agree that you have complete discretion to rescind or waive the penalties. And the statute says so right in it that you could mitigate or waive penalties on the terms and conditions in your discretion you deem proper or necessary. That's, right in the statute. There absolutely is precedent for you to do that, to waive any and all penalties. In fact, I know we filed hundreds of documents, so it's hard to have things jump out, but we cited precedent for you on Bait Stamp 36. It's docket number 1231797. That is also precedent allowing you to completely waive and rescind the penalties. Also, as part of our legal brief that was filed in this proceeding on date stamp 25, we stated OHS is explicitly permitted under law to mitigate or waive the penalty upon such terms and conditions in its discretion it deems proper or necessary, based upon facts and circumstances. And we cite the statute, which gives you that authority. And we also go on to state that if a global pandemic, a nationwide healthcare worker shortage, and a statewide pediatric behavioral health crisis are not extenuating factors or circumstances for a small community hospital like Rockville, it's really incomprehensible what qualifies if those don't. So yes, we agree that you have full authority to take that action.
Okay, thank you, Ms. Volpe. So now we can move on to closing arguments. I'm going to start with Ms. Manzione for the petitioner. Do you have a closing argument that you'd like to present?
Yes, I do. And it will be relatively brief. So I will go ahead and jump in. To stay with my theme,
I did
rules
just want
are-
to say, I'm sorry to interrupt, but even though this was scheduled for 2 hours, we are free to go over that. So don't feel as though you have to be brief. Similarly, Ms. Volpe, don't feel like you need to be brief either. Excuse me.
Appreciate that.
Thank you. I didn't realize we were scheduled for 2 hours. I was thinking it would be an hour total, and here we are at 2.5 hours. So anyway, okay. All right, I'm going to go ahead and start my closing argument then. Okay, so rules are rules. Everyone has been told that at some point. We know we are expected to follow the rules. We are expected to know what the rules are, even when the rules are complicated. Especially in a regulated industry like healthcare, we all have to follow the rules. You can't make up your own rules. You can't say you relied on a different interpretation. It doesn't matter that you argued in a different proceeding that the public health emergency was the trigger for the CON waiver expiring. If the governor makes the rules, the governor can change the rules. Rockville General Hospital thinks they know best. Rockville General Hospital think they should interpret the rules made by the governor. Executive Order 12B didn't mean what the executive branch of the government says it means. It should mean what a private for-profit hospital says it means. In July 2021, the governor said that the executive director of OHS's authority to grant CON waivers expired. Rockville General Hospital didn't listen or follow that rule. In October 2021, the Office of Health Strategy told Rockville General Hospital what the rule meant. And once again, Rockville General Hospital didn't follow the rule willfully. The Office of Health Strategy said Rockville General Hospital should be back at, quote, pre-waiver status, end quote, by now. And Rockville General Hospital didn't agree. It didn't follow the rule. Rockville General Hospital kept its surgery services closed when it should have opened them. Rockville General Hospital broke the rule. In November 2021, Rockville General Hospital filed a termination, arguing that they didn't need to file a CON. Rockville General Hospital willfully kept its surgery services closed when it had been repeatedly told it should have restarted them. In January 2022, OHS issued a decision on the determination that Rockville General Hospital should file a CON or start the services which were still closed. RGH willfully continued to keep its surgery services closed. And finally, when they didn't receive the answer they wanted from the determination, the CEO of Rockville General Hospital tried a different approach by sending an email directly to the executive director of OHS, pleading again to extend the waiver. The CEO was still under the impression that the rules didn't apply to her or the Rockville General Hospital. The OHS executive director did not reply to this email message. A civil penalty is another type of rule. It is a consequence for breaking rules. In this case, Rockville General Hospital broke the rules by not resuming surgery services by October 2021, or by not requesting a CON to terminate surgery services once the authority of the executive order ended. Even though Rockville General Hospital stopped breaking the rules when they restarted surgery services on February 16th, 2022, they still must pay the consequences for breaking the rules. And that costs $1,000 a day from October 22nd, 2021 to February 16th, 2022, for a total of $118,000. That's what you get when you break the rules. And this tribunal has the power to enforce the rules. Thank you.
Thank you, Ms. Manzione. And Ms. Volpe, do you have any, would you like to make a closing argument or a closing statement?
Yes, I would. Yes, I would. So there's been a lot of talk about the rules, okay? The rules are the statutes. The rules have to apply when you want to impose a civil penalty on a hospital. To impose a civil penalty against the hospital, you have to prove, you, OHS, have the burden of proof. You have to prove that we failed to file a CON and that we terminated a service and that we willfully did not file the CON, that we were looking to usurp the CON statutes. Again, you have not met your burden. One, because we didn't terminate a service. So the statute doesn't even get invoked. Two, we certainly didn't act willfully. We followed your rules, OHS's rules, which, by the way, we have hundreds of pages where your rules were changing, sometimes hourly and daily. Admittedly, we were dealing with a global crisis on the pandemic. So do we give you some leeway in your constant changing of guidance? Yes, but we expect the courtesy as well. We followed the rules. Your rules are apply for a waiver. We applied for a waiver. Your waiver said, if you're going to terminate, come back to us. It said your waiver's in place through the public health emergency. Following your rules, marching along, you knew what our intent was. You understood what our intent was. Intent is very important under the civil penalty statutes. You can't impose a civil penalty against us if we understood that we were in compliance. And it was reasonable for Rockville to believe they were in compliance because based on your words, it said we had through the public health emergency. Also, based on your words, it said that we would only be required to file a CON if we terminated a service. And I want to speak to hearing officer, your question on what did Ms. Weymouth understand a distinction between a formal and a formal termination? No, as a layman, we all know either you terminate or you don't. As a hospital executive, you're providing services. Either you're providing services or you're not. They're terminated. I think there's a plain reading and understanding of a termination. But then I ask, why does OHS, if we're talking about words and words are so important, why do they reference formal termination? Is there such thing as an informal termination? No, I think the distinction is in suspension. There's lots of precedent before OHS dealing with suspension of services. So when you said formally terminate, perhaps you're making a distinction between a suspension versus a termination, a formal. You use the word permanent termination. Again, in decisions we got from you on these very issues. Again, permanent, that means not to ever be brought back online. Totally distinguishable from suspension. So I do think, like we've been talking about, the words matter, yes. But what does matter is the law. And what is the law related to a civil penalty? You, OHS, have the burden of proof to show two things, neither of which you've shown. One, that there was a termination of service and we had to file a CON. And two, that we just willy-nilly went about our business trying to usurp the CON statutes and not comply. So when you apply the facts in this case to the law, which OHS is required to do, they don't support the imposition of a civil penalty against Rockville. There was no termination of service and there was absolutely nothing done willfully. OHS carries the burden of proof in a civil penalty proceeding, and OHS has not met its burden. Rockville did not terminate the service, let alone formally or permanently, again, using your words. They were suspended during a once-in-a-lifetime global pandemic. Without termination, there is no violation of the CON statutes, because that's when they get invoked, if you're going to terminate. In addition, OHS has the burden and must prove that Rockville willfully failed to file a needed CON. In my opening statement, I detailed for you what constitutes willful failure, and this most definitely has not been established by OHS. It is what is the intent of the person, and Ms. Weymouth testified on a number of occasions what their understanding was, how they were proceeding, and there was no willful intent to invade the CON process. There's been no malice or intent to deceive OHS. Ms. Weymouth has represented under oath on numerous occasions and made multiple representations to the Office of Health Strategy that her understanding was that Rockville had, through the public health emergency, to re-implement services on February 16th. Nothing, no decision that OHS sent to Rockville talked anything about. It all specifically said you need a CON if you're going to permanently and formally terminate services. Rockville has shown how it's impossible for OHS to meet its burden because none of the statutory elements exist that are legally required for OHS to impose civil penalties against Rockville. OHS has failed to present any evidence that Rockville violated the CON statute. We respectfully request that you rescind the penalty, which you have full authority to do. Thank you.
Thank you, Ms. Volpe. There was one other thing that I wanted to bring up to both of you. It was the fact that Ms. Volpe, you filed a legal brief, and actually I believe you raised this earlier on in the hearing. You had filed a legal brief in connection with your pre-file testimony. Ms. Manzione, you did not, but regardless of that fact, I was curious if either of you wanted to file a post-hearing legal brief as well. So Ms. Manzione, would you like an opportunity to do that? And then Ms. Volpe, I will ask you as well.
Well, I mean, if I'll leave it up to Laura, but
Okay.
I will say this, that we don't intend to file a post-hearing brief. However, if OHS elects to file a post-hearing brief, we would also like the opportunity to file a post-hearing brief.
Noted. Ms. Manzione, do you have a position on that?
Sorry, I was speaking, but apparently I was speaking into the mute button. If it would be helpful for the hearing officer for me to submit a post-hearing brief, I would be happy to do so.
I don't think it would be, honestly. So my suggestion would be that neither of you file them. I don't think it's necessary, and I don't want either of you to do unnecessary work.
Okay,
That works for us.
fair enough.
So, I'm sorry?
I said that works for us.
Okay, thank you.
So it stands that there will be no post-hearing briefs?
Correct.
Okay. Okay,
Are there any other loose ends that you, either of you wanted to address at this time?
I have a loose end. I don't think it's a loose end per se, but I was waiting to hear whether or not, post-hearing briefs were going to be submitted. Hearing that post-hearing briefs will not be submitted, we respectfully request that this proceeding be closed and the record be closed, and that there be no additional filings, so that the record could be closed at the conclusion of this hearing today.
That was going to be my plan, to adjourn the hearing and close the record. So
Great, thank you.
we are thinking alike.
I support that idea as well.
Okay. So with all of that said, I think we're all set, and we can adjourn the hearing and close the record. So thank you both. And thank you to your witnesses. It was very helpful, and I appreciate your time.
Thank you.
Thank
I
you.
appreciate your
Thank
time.
you.
Thank you, Attorney Manzione. Thank you.
Thank you, Attorney Volpe.
Mr. Lazarus.
Thank you, Jess. Thank you, Roy.
Thank you.
Thank you, everyone.
Thank
Thank
you.
you, everyone.
Okay, we're gonna sign out.